the defendant in their application, they now want to distance themselves from the admitted fact in their plea. We
Right.
submit that.
All right. Let's move away from that, Mr. Quinta,
Okay.
and address. I think the focal point is here is what is the amount that this court must award if it finds in your favor.
That is correct.
Ultimately, if judgment is given.
All right. I'll come to that.
All right.
On our heads of argument,
Yes.
your ladyship will say that I think I need to start from on case line is section 030-24. On case line deals with under paragraph 33. Sorry, my apologies. On our heads of argument,
Yes.
paragraph
Paragraph.
paragraph 33 and 34. Paragraph 33 and 34. One, deal with the St. Michele annual financial statement as of March 31st, March 2016.
Mhm.
Your Ladyship, with your permission, I just need to close the door. There's a noise in the background.
Yes, I can hear that.
Yeah, but I'm asking just for a second just to close the door.
So
My apologies about that.
that's fine.
Hey, show me. Hey, show me. Okay. Thank you, Your Ladyship. My apologies about the noise earlier.
Fine.
To answer to the court question that which amount should the court find in favor of the plaintiff? I'm going to respond as follows. From the plaintiff, it's of argument in opposition of the absolution from the instance, we submit that there's a prima facie case against the defendant, and that prima facie case, the ladyship will see that on paragraph 33 and 34, we have indicated that one, having regard to the annual financial statement of St. Michele, at the end of the financial year end, there was a cash at hand during the year 2015. And the leadership will see that on paragraph 34 of the plaintiff heads of argument. And again, the leadership will see on paragraph 36 of the heads of argument, we have indicated that as per the financial annual financial year statement, it was recorded that at the end of the year of 2016, there was an amount that was available. And most importantly, during the year 2018 or annual financial statement of the year ended 31st March 2018, the accountant of Saint Michele have expressed an opinion that, or they've stated that they cannot express an opinion on the completeness of the income, and that it was stated on the financial statement by of Saint Michele. And furthermore, it is our submissions that in support for the dismissal of the application for
No. So what is the amount that
okay,
you say you computed as owing to you? What is the
that is
amount?
correct. If your ladyship will bear with me, I'd like to take the court to the
Because
heads
you
of
must
argument.
remember, if the court has to give judgment, it has to have the amount proved, and that
That is
has to
correct.
be proved.
All right. Uh, our submission is that if your ladyship will bear with me, on paragraph 60, 61, 62,
Sure.
up to 66, it deals with the Send Michelle annual financial statement for the year ended 31st
No,
March
no,
2026.
no. Just tell me your what is it? How much is it you are contending? And then we will go to how you arrived at the calculation. Give me the exact amount that you say this court will be able to find that is the amount owing.
Okay. Your Lordship, I need to bring to the court's attention that there are two things. One, I
Yes.
submit that those calculations, I've made those calculations, and
Yeah.
I'm not saying that I'm an accountant myself, but
Yeah.
however, prima facie having regard to undisputed evidence that at the end of each financial year and the monies are available, the leadership will see that I've indicated that on paragraph 62, that based on my calculations for the year ended 31st March 2016, the amount uh, that is due or to be refunded to the Department of Health was 517,102. The leadership
So
will
you
find
say
that
paragraph
62.1 of our
just
heads
hold
of argument.
okay.
Then your leadership will find that on case line 030-32. And
Sorry, where did you zero?
62 030-32.
Okay.
Then your leadership will see that we have by calculation came to an amount of 517,102.
So that's
And
at the end of the financial year of 2016. You're saying
2016,
they were overpaid 517,000.
that is correct. How
So
I arrived,
isn't that a contractual claim?
your
How
leadership,
how how do you bring it with the tribunal? Simply on the basis that you can sue for any claims.
of the SIU Act,
Mhm.
the SIU is mandated to institute any civil claim and on his name or on behalf of in terms of the SLA agreement. There is a clause which states that at the end of each financial year end, the service provider should refund the unspent surplus or unspent subsidy that was provided by the MEC for Health or Department of Health. And having said that, in their heads of argument, the defendant do refer to that clause which states indeed that unspent surplus or subsidy should be refunded to the department. And while I'm still on the issue of unspent subsidies or monies that are due to the MEC for Health, we have indicated on our head of argument that no version was put to the plaintiff witnesses that in fact the defendant at the end of each financial year end, this is this is what the supply they had, and this is the amount that it was refunded or paid back into the MEC for Health. And we're saying that in the absence of that version that was put to contradict, more especially the evidence of Mrs. Mguni, that no surplus were refunded, it is our respectful submissions that that version of the plaintiff witnesses remain unchallenged, and therefore we humbly request that the Honorable Court, when considering this application or dismissing this application, to consider common cause facts and to consider the defendant failure to put any contradictory versions or evidence to explain that in fact the defendant they've paid unspent or monies that were 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 not utilized during that financial year end. And if with the court's permission, I also like to go back to paragraph 60 of the plaintiff heads of argument. the leadership will see on paragraph 60 of the different heads of argument. One, we have dealt with the donations that were received by Saint Michel during the year 2016, the fundraising for the year 2016, and the parents' fees that was received, and also the sundry income, and also read together, and workshop income. So these are the total amounts that Saint Michel have mentioned in their annual financial statement. Then the prima facie evidence comes in as follows. That one, we have a total cash in hand at the end of the year of March 2016, based on the document that was discovered by the defendant. We have a donation, cash at hand at the end of the financial year end was 1,580,153. Then, having regard to the donation, was an amount of 508,670,000. Then we have a fundraising by Saint Michel, which is an amount of 384,697 cents. And we've got parent fees in an amount of 137,232 cents, 32 rand. And we have a sundry income in an amount of 16,246 rand. Lastly, we have a workshop income in an amount of 16,206 rand. Then our submission is that one, in regard to the figures as they appear in their own financial statement, the defendant, there's a prima facie case that the defendant, they need to tell the court that this amount of 517,000, where does it come from? Because from their own audited financial statement, it shows that cash at the end of the financial year was 1.5 billion. We deduct whatever amount that we see from the financials. However, we submit that there is a prima facie that the defendant we need to come and explain as to how this amount of 517,000 came from. And while I'm still on that, I also need to refer the court to the defendant in their plea, in which I'll get the relevant paragraph. But okay, with the court permission, may I be permitted to move to the financial year for 2017?
Okay.
In which your leadership will find that on paragraph 64, 65, and 66, on section 030-33, we indicated, or it was according to the Saint Michel annual financial year end, 31st March 2017. Then we look at the donation that was received in an amount of 372,285 rand. The fundraising for the year was an amount of 323 rand, 285. Resident income, an amount of 3,000 rand. Parents' fees, an amount of 124,005 rand. Sundry income, 7,199. Workshop income, 34,439. Total cash at hand at the end of the financial year end of 2017 was 2,278,552 rand. And I've referred the Honorable Court to a relevant page on case line. Now, if in regard to the cash at the hand of 2.2 million at the end of March 2007, we have taken the same process of donations, fundraising, sundry income, resident income, and also parents' fees, workshop income. Then the total amount that came there, it was an amount of 1,414 rand, 339 rand. And therefore, we submitted that the defendant did not return unused or unspent monies or subsidies to the second plaintiff. And for the year 2018, 31st March 2018, the same process was done, your lordship will see on paragraph 67 of the plaintiff and aids of argument. The total cash at the end of the financial year in 2018 was an amount of 2.9 million. And we've referred to case relevant pages of case that section 029-127 and section 02019-130. Then on paragraph 67, we've indicated that there were donations that were received in an amount of 347 rand, 429 rand, fundraising in an amount of 122,890 resident income, in an amount of 37,615 sundry income, in an amount of 52,469. The total cash at hand was 2.9 million. So what we did on the paragraph 68 of our head of argument, we took the total cash at hand, minus that with the donations, fundraising, resident income, sundry income, and that came to an amount of 2.9 million. Why I'm taking your leadership through those calculations as prima facie they appear, or as they appear on the plaintiff heads of argument, is to show to the court that prima facie the defendant have a case to answer. From their own financial statement, it shows that there was cash at hand at the end of the financial year. And from their plea, they've admitted that indeed unspent monies or subsidies should be refunded to the second plaintiff. What I wanted to bring to the court's attention is that, yes, in terms of our amended particulars of claims and also the calculation that it was mentioned on our heads of argument, the amounts are totally different. However, I need to make the following submissions. That one, in terms of the provision of Rule 28 of the Uniform Rules of Court, amendment can be made at any time before the judgment. Number two, in our amended particulars of claims, we've asked for further and or alternative relief. Number three, having regard to undisputed fact and common cause fact, it is our submissions that the evidence that is, I need to emphasize the evidence of Ms. Mugoni, that one, there should have been a one bank account in which the subsidy of the department goes into that bank account. And number two, at the end of the financial year end, NGOs or service providers, in terms of the SLA agreement, they were expected, one, to give a one-page letter confirming the amount that were still available at the end of the financial year end. And Ms. Mugoni gave evidence that for the department to allow the service providers to provide one-page audited report is to show the amounts that were paid, or the subsidies that were paid into service providers. However, the leadership will recall that Ms. Mugoni indicated that here we've got Saint Michele doesn't have to have only one bank account, and Saint Michele have indicated that they received donors or donations from other third parties. And we have seen from their own annual financial statement the donations that they received, including other incomes. Having said that, I think it's important to leadership that I bring to the court's attention again to show that there's a prima facie case in which the defendant they need to answer or explain to the court. On our heads of argument, paragraph 15, on case line section 030-17, the defendants in their plea, this is the amount regarding the amount. They've said that we have said as follows on paragraph 15 of our heads of argument. that an amount as alleged of 500,000 is an overpayment is more than what was actually received from the second plaintiff. I've referred the court to the relevant paragraph of the defendant plea on case line of section 008-7. And the defendant in their plea, they say that they deny that such an amount constituted an overpayment. This is why they've pleaded in their plea. That we are saying, Your Ladyship, that in the interest of justice and take into account that these are public funds, and the main aim of the SLA agreement when it was signed by parties was to assist or was to provide services to mentally ill person. But now here in this case before you, we have found that prima facie from their own financial statement, to date they remain unaccounted for. The court is not being told where those funds originate from, but we submit that it will not be in the best interest of justice and public that absolutely from the extent be granted, in which in fact it shows that funds or public monies were sent to first defendant and no reasonable explanation or version was ever put to plaintiff witnesses that in fact those monies they don't belong to second plaintiff. Then on that point, we humbly request that if the court finds that prima facie there is an evidence that the court will find in favor of the plaintiff, as I've indicated earlier, that the issue of amendment can be brought at any time before.
Sorry, this amendment, just remind me, it's been a long time, Mr. Kwenda, which amendment was this?
No, the amended particulars of claims.
Yes. Have they been amended already?
No, they've never been amended. There was an amendment on section 006-1.
So was there an application to amend?
Initially, what happened? There was a combined summons that were issued. The defendant issued an exception. Then there was notice to amend particulars of claims, and there was amended particulars of claims. Thereafter, the defendant has pleaded to the amended particulars of claims.
So the amendment was then accepted. Is that what you say?
Yes, before the trial.
No, my lady, that's not correct. There was a practice management meeting held by Her Ladyship Ladyship Madiba, and it's in my heads of argument where she directed that the exception will be dealt with at the trial issue.
Your Ladyship, what I'm referring to the amended particulars of claims. Your Ladyship will find that under bundle A, pleadings, trial bundle.
Sorry, what? Repeat that, Mr. Kwenda, please.
Bundle A, pleadings, trial bundles. Then there was a combined summons. The combined summons were issued on the 6th of November 2019. The Ladyship will find combined summons under section 001-1 to 001-16. Those are our original particulars of claims. They are on bundle A of the trial bundle.
Yes.
Therefore, there was on the bundle A of the trial bundle, there is amended particulars of claims dated 17 August 2021. Then Your Ladyship will find amended particulars of claims on 006-1 up to 006-15. Right. Then Your Ladyship will find first, second, and third defendant plea The first and second defendant plea is start from 008-1 to 008-22 together with annexures. Then here the defendant, they've raised special plea. The first pointing limit, I was dealing with the course of actions against the second and third defendant. The second pointing limit, they were dealing with the alleged innovation, and therefore they've pleaded to the amended particulars of claims. Furthermore, I need to bring to the court's attention that there was replication to the defendant special plea or pointing limina and plea over. The lordship will find plaintiff replication on section 009-1 to section 009-9. That your lordship will find on bundle A of the pleadings. So during my address, I've indicated where I was dealing with amounts that are available at the end of the financial year end. I've indicated that I've made submissions that prima facie, there is a case the defendant they need to answer. The defendant they need to tell the court.
So these amounts appear in your amended particulars of claim, not in your original.
No, the amounts on my heads of argument, they don't appear, one, on original particulars of claims, two, they don't appear on the amended particulars of claims of 17 August 2021. Then we're saying, prima facie, I've made submissions that I'm not an accountant myself, but one even regards to prima facie evidence. We're saying, your lordship, that if this application is dismissed, then we are saying that even regard to the provision of the Rule 28 of Uniform Rules of Court, which says that amendment can be brought at any time. We are saying that once this application has been dismissed, then we, the plaintiff, and we will bring an application to amend our amended particulars of claims. In our amended particulars of claims, the amount that was claimed is an amount of 2,117,559.18. The lordship will find that under section 006-13.
Sure, I'm really confused now. I really am. What are you? I don't know.
What we are submitting, your lordship, is that
this is really very, very confusing, because this whole thing has not been dealt with. Now I have to deal with amended particulars of claim and an amendment of an amendment. I don't know where we stand here, Mr. Quinda. Okay. You've got to make out your case. Okay. We've proceeded with this trial.
That is correct.
And now you talk about amended, that you want to bring another amendment. Really, I really don't know what's going on. I'm totally confused.
May I make the following submissions, your lordship? Our submission is that from the papers that were discovered, or that form part of the evidence before court,
yes,
there is a prima facie case against the defendants.
Without the amended particulars?
Without the amended particulars.
Okay.
We are saying that if one have regard to their own annual financial statement, what they've received from third parties in the form of donations, workshop income.
But is that the amount that you've sued for?
The amount that we sued for is an amount of 2,100,000.
Yes, is that in your original particulars of claim?
In our original particulars of claims, I need to get to the original particulars of claims. In the original particulars of claims, the amount that we sued for, it was 2,832,628.20 in the original particulars of claims. Then in the amended particulars of claims, that amount moved from 2.8 to 2.1 million.
So it was reduced.
Just reduced in this.
Okay.
Then, as pleading stands, the amount the plaintiff claimed, as per amended particulars of claims, was 2.1 million.
Okay.
Right. Then, what we are saying or what we are submitting is that, Your Ladyship, one, having regard to the evidence that was placed before court, we accept we have pleaded an amount of 2.1 million. And on our heads of argument, I need
Well,
to
that's
plead.
fine.
Okay.
In any case, you didn't need the amendment, because if you only prove less, that's the only judgment you're going to get, obviously.
Then, there's another point that I wanted to move on. I don't know if maybe Your Ladyship would like me to address any other issue.
Well, what is your case as far as, remember, we are a tribunal. Whilst we might be allowed to institute civil, I have jurisdiction only as a reviewing court. Remember Ledla's case.
I did have a look at that judgment by the Constitutional Court.
Yes.
And when
so right. So before I finish, so what is the basis on which I can now review this decision? Because can I now step into the shoes and institute a civil claim, which you could have done in the first place on basis of the contract?
Okay. With regard to the judgment of the, may I start with the judgment of the Court? I can't recall the name of the judgment.
State versus Ledla versus something.
Later in this. So when these summons were issued, I accept there are a number of matters that were instituted at the special tribunal.
Yes.
Then difficulty with that judgment. The Constitutional Court didn't pronounce that what will happen with the pending action proceedings or applications at the special tribunal. Then we're saying, Your Ladyship, even regard to, we know that section 174 of the Constitution says that the court has inherent jurisdiction. Then is the issue of discretion to be applied by the court, even regards, one, to the interest of justice, number two, the nature of the matter before you, Your Ladyship. And that judgment does not state that all pending matters before the special tribunal should be dealt by the civil trial. However, we submit that even regard that this matter was argued or was heard before you for a period of 5 days, evidence was led before you, Your Ladyship, and we're saying that, taking into account the administration of justice, it will be fair and also in the interest of justice that this matter be finalized in a special tribunal. And if the Constitutional Court had an intention that all pending matters before the special tribunal, which were issued or instituted before the judgment is granted, then I believe that the Constitutional Court might have given directive as to how to deal with it. But we're submitting that, having regard to the inherent power that Your Ladyship has in terms of the provision of section 174 of the Constitution, Your Ladyship is properly based to deal with this matter. Then it's section 173, my apologies, it's not section 174. Section 173 deals with the inherent power of the court. My apologies, Your Ladyship. Well, what we are saying is that if one have regard to the provision of Section 8.2 of the Special Investigations Act, I accept that it didn't deal uh, with that on our bit of argument. However, it gives the court the power to give appropriate relief or order. And earlier on, I've indicated that we have, on our amended particulars of claims, we have asked for further or alternative relief. And having said that, Your Ladyship, is that we believe that from the evidence as they presented before you, the defendant have a case to answer, and therefore application for absolution from the
So,
instance.
are you saying the second and third defendants? What is the case against them, Mr. Quinda?
In this, the case against the first and second defendant.
No, the second and third.
My apologies, but the case against the second and third defendant.
Yeah.
The evidence of Miss. Remember, is which my little colleague Ruwumbi, the leadership will find that on our heads of argument, section 030-8, is the witness statement of Mr. Remember Ruwumbi, the second defendant. And furthermore, the leadership will recall that communication between Mr. Bosman and Ms. Plant of the SIU.
So are you saying that I have to? But what is the basis if somebody signs a form as he? What is the basis? You have to bring it on what? Just because they signed the form. What is your contractual agreement or delictual agreement against? I mean, or delictual basis against them? What is it? What is just because he signed the form, he now has to be liable? Is that what you say?
No. We have dealt with it extensively on our abandoned particulars of claims. The basis, in fact, on the replication, the basis as to why the second and third defendant were cited as the defendant. Then, if the leadership will bear with me, we indicated on our replication as to why the second and third defendant were cited. But however, while I'm still on the head, I'll come back to the relevant paragraph in our replication. We are saying that the second and third defendant, whom at all material terms.
So sorry, Mr. Quinta, can I just stop these proceedings? I just have a family emergency. I just want to attend to for 1 minute. Sorry, I'll rejoin you in a minute. Sorry. Okay, 1 minute. Thanks. Sorry. Thank you. Thank you. Can you hear me?
We can hear
As a
you,
call, please, Ms.
Your Lordship.
Yes. Thank you
As a
very
call,
much.
please. Your Lordship, we were still on the issue of why the second and third defendant were joined as a parties
Yeah.
to the proceedings.
And you referred me to the amended particulars of claim,
That is
which
correct.
which you say has been accepted, which Mr. Marlin says have not been accepted. So
Okay. As a copy, my lady.
okay. So I'll hear from Mr. Marlin about these amended particulars.
All right.
So,
The Lordship, sorry, the Lordship phone was, I think, was frozen for a minute. Okay.
sorry.
All right. I'd like to make the following submissions regarding as to why the second and third defendant were joined as a parties. The Lordship will see on our heads of argument section 030-27, the relevant paragraph is paragraph 45.
Mr. Quinder, I hear you, but can I deal when you're dealing with referring to your heads of argument? Can you just perhaps just deal with the paragraphs? Because remember, we don't have case lines.
Oh, my apologies.
So
Okay,
it's much easier if you just simply refer me to the paragraph. Sorry.
I will do it though. I will do it.
That's
It's paragraph
fine.
40. It's paragraph 45.
Yes.
Computerized page 27.
Thank you.
What the plaintiff have pleaded is that the first defendant through the second and third defendant, they failed. I'm paraphrasing. That will find in paragraph 21. That they failed to adjust their monthly claims in accordance with the surplus funds in the first defendant account. We are saying that as a defendant, as a plaintiff, that the first defendant is it's a legal entity, NPO, and in which it had its directors, and in which the defendant, second and third defendant, they cannot say that because in their plea they cannot now want to distance themselves from the actions of the first defendant, and we submit that an authority was given either to the second or third defendant in order to manage the affairs of the first defendant. And we submit that the second and third defendant, they should be stopped from now wanting to distance from themselves from the actions or conduct of the first defendant. Because in their plea, the second and third defendant admit that they were acting in the course and scope of their duties, and they've pleaded that they've acted in good faith and with a reasonable execution of their duties. And they further deny any failure to adjust their monthly claims. Then we're saying, having regard to the fact that the third defendant, in his capacity as an administrator of the first defendant, we've mentioned that on our heads of argument, commissarized page 28. Then the third defendant have signed an acknowledgement of debt in an amount of 71,000. That your leadership will recall that that amount was relating to the overpayment of SASSA.
That has been paid.
It was paid in this sum. Why we're bringing this to the court's attention that in their plea they're saying that one, they've acted in good faith, and number two, they've acted in reasonable in exercising their duties. But we know that due to the investigation by the SIU, two amounts were paid. That was the SASSA payment, and that was again another amount of approximately 1.4 that was repaid back to the second plaintiff. And we are saying on the issue of citing the second and third defendant, we submitted or it was pleaded that the second and third defendant, they had a responsibility to oversee the duty of care and also the financial part of the first defendant. Then we submit that I need to reiterate the fact that the second and third defendant, they cannot come now, want to distance themselves from the authority that they had in representing the first defendant. And I reiterate that it is the defendant plaintiff's submissions that the plaintiff were correct in citing the second and third defendant. And we accept, Your Ladyship, that on our aids of argument, this is a question of law. We didn't deal with it that the second and third defendant to be stopped from wanting to distance themselves. However, we submit that having regard to what they've pleaded, and it was appropriate for the plaintiff to have cited them on these proceedings. On the last issue that I'd like to make, submissions were made that application for absolution from the instance be granted with a punitive cost order against the plaintiff on an attendant client's gate. I'll submit as follows. We accept that the issue of cost is a discretion of the court. Number two, we submit that there's no basis that was made for a punitive cost order. And number three, we submit that from their own admitted fact in their plea and also prima facie from their own annual financial year statement, there is a prima facie evidence.
So in effect, what you're saying is that in those financial years you've mentioned, there's the surplus that they should have paid back, and that's the basis of your claim.
That is why I'm saying that from the financial statement.
And that in terms of the SLA, they were obliged to repay those amounts, which they didn't.
Which they didn't, that is correct. Then the defendant must come and tell the courts that
why they didn't repay in terms of the SLA.
That is correct. Why that 517,000 was never repaid to us? Was that 500,000 come from third-party donors? We don't know, but we know that from their own annual financial statement, they've mentioned the amounts that they receive from the donors, workshop income, parents fundraising, parents fees, and I can't recall the other one. So they have to come and tell the court that yes, there's money in terms of our annual financial statement, the source of that surplus. And we and I know I've said
let me before we go longer, I've got to tell you we've in power failure, okay. And my since I've been using my other device is not working. I've been using my phone for these proceedings, and the battery has gone quite low at the moment. So I'm just worried that we don't.
Okay, no, I'll finish. I'm
and
closing.
Also, I'm gonna have a problem with the mobile data lasting that long. So,
okay. Okay. In conclusion, we're saying that one, there's no basis that was made for punitive court against the plaintiff, and we stated that we as the plaintiff acted reasonably, looking in the interest of justice and also the public funds, that the monies that we paid, and in which prima facie from their own annual financial statement, there are monies that to date they remain unaccounted for. In conclusion,
Sorry, I'm just trying to get some light.
okay, it's fine, Your Ladyship. In conclusion, we submit that one, the application for absolution from the Eastern to be dismissed. Two, we're requesting for cost on an attendant landscape or any other punitive cost order as the court may deem fit, having regard to the most importantly, the fact that for the first time in the height of argument that dealing with the alleged lack of jurisdiction, despite that they've admitted same in their plea. Having said that, Your Ladyship, we submit that no case have been made for absolute from the Eastern to be granted. And number two, on the issue of cost, there is a clause which we have pleaded in our amended particulars of claims and also on height of argument in which the defendant they've said that there's a clause which says that the defendant indemnify the second defendant for any legal cost order. It is there on our height of argument. Unfortunately, I can't get it. I cannot get it now, but it was mentioned on our height of argument that in terms of the SLA agreement, the service provider indemnify the Department of Health from any legal costs. That's a core process. On behalf of the plaintiff, I have no further submissions to make, Your Ladyship.
Thank you, Mr. Kwenda.
Thank you, my lady.
Mr. Morland, yeah.
May it please you. My lady, in respect of the first issue that my learned friend suggests that the jurisdictional issue cannot be raised because it is admitted in the plea.
I'm here.
May I please you. My lady, it's not admitted in the plea. What is admitted is the statutory entitlements for the SIU to institute a claim based on proclamation. That is what is admitted, and that's what would give them locus standi. It doesn't mean that this tribunal has jurisdiction. It just gives the SIU locus standi. What my learned friend doesn't deal with is the case authority which says that the issue of absolution is not dealt with on the defendant's plea. It is whether or not the plaintiff has proved the requisite factor probanda to place it within the court's jurisdiction and to establish their claim. But more to the point, my lady, if I could just point out that the issue of jurisdiction arose by the defendants only on the basis of the fact that Mr. Pillay said in cross-examination, he conceded that based on his own case, none of the facts in question fall within the ambit of the proclamation. And that is why the jurisdiction issue was raised. Her ladyship will not.
Was the plea taken on the jurisdiction issue?
No, my lady, it wasn't taken because the defendants accepted that the plaintiffs may have some basis to prove that the facts may fall within the ambit of the act. So if they are clearly contending that there is some issue which would bring it within the claim. But then when we asked Mr. Pillay, but what is this thing based on? Because none of the facts that you've spoken about fall within the proclamation. He said, yes, I accept that they don't. And that is when we said, but then on that basis, you haven't provided evidence upon which this court actually has jurisdiction. My lady, I would just point out that it is a different issue in a civil claim. In a civil claim where you don't bring the jurisdiction of the court into question, you then accede to the jurisdiction. But this is a special tribunal as a creature of statute. And the claim that the tribunal only has jurisdiction insofar as the proclamation gives the tribunal jurisdiction to adjudicate on the claim. And when we heard evidence from the defendant and we were able to ask them, but what facts do you rely upon to bring it within the court's jurisdiction? He said, no, well, I accept that it's not. Her ladyship will recall at that point, her ladyship said, but then is there any point in proceeding with this? If you accept that there's none of these facts. And then we heard the rest of the evidence to hear if indeed there could be anything which brings it in. And we, in the realm of a civil claim, at best, an unsustainable civil claim, which hasn't been established prima facie, but it doesn't fall within the jurisdiction of the tribunal. My learned friend made submissions concerning inherent jurisdictions. Although Her Ladyship is an appointed judge of the Superior Court, Her Ladyship sits as the head of a special tribunal as a creature of statute. So whilst Her Ladyship sitting as a judge of the High Court has inherent jurisdictions to regulate processes and the like, I'm not certain that in a creature of statute the same applies. But that submission seems to be predicated on an acceptance that we are not within the realm of the proclamation and the statutory creation of this tribunal. My lady, I take that issue no further. My lady, on the issue of what my learned friend refers to in terms of the audited annual financial statements, Her Ladyship will note that the service level agreement requires any unspent monies of the state money, of the stipend given in terms of the SLA, that must be repaid. However, my lady, when one has a look at cash on hand, it is common cause that this not-for-profit organization gets donor funding, private donor funding. That is not state money and not subject to repayment. What my learned friend seems to be now placing the case on, and I will submit that what the plaintiff is doing goes along. It's tailoring its case to try and fit the suit that it's brought. With respect, it's unacceptable. It's an abusive way of conducting
Well, let's deal with those amendments. Before we even get there, this whole confusion about when there's an amendment, whether that amendment has been granted, whether there's an application. I'm quite, it's been a long time, so I've done so many matters after that, and I'm totally confused. So if you could just assist as well, please.
Yes. Her Ladyship wouldn't be aware of that because Her Ladyship wasn't seized with the matter as the court giving direction on how. But what happened, my lady, is a summons was issued.
Yes.
The defendants raised an exception. It may well actually have been that there was a sentiment that one needed to raise a plea and an exception simultaneously in terms of this tribunal's rules. But in due course, there was a case management meeting that was held. And what was decided is that the issue of the exception will be decided at trial. And we're not getting into that issue now. We need to get on to the merits of the issue. What happened is that the plaintiff then amended its particulars of claim, and a plea was given in terms of that amended particulars of claim. It doesn't really make
but we are in the trial, so we are in the trial now. So you said the issue of the exception, was that dealt with during the course of our trial?
No. Her Ladyship, Justice Madiba, said, I understand Her Ladyship's question is, have we dealt with it? The appropriate time to deal with it is now, having heard all the evidence. So insofar as I understand and construe the rules as well as the direction given by Her Ladyship, Justice Madiba, is that hear the evidence and get on with the matter, and you can deal with whether there was any claim to be made against the second and
based only on the one side, and deal with that issue as well, because obviously the amended particulars of claim will have an impact on the evidence that was presented.
So the amended,
as to whether or not there is a prima facie case.
So it doesn't make any practical difference for the following reason.
Okay.
Her Ladyship doesn't have to rule on the exception. Her Ladyship can simply say there's no case made out against the second and third defendant, and therefore it is unnecessary for me to rule on the exception. But Her Ladyship can do both if Her Ladyship looks at the pleadings as it concerns the second and third defendants.
But if the amendment clarifies the case against the second and the third defendant, how can I just ignore the amendment?
I'm not suggesting Her Ladyship should. I'm saying that even still, it doesn't make out a claim against the second and third defendants for the following reasons. Let me read to Her Ladyship what the plaintiff made payment of the amount. Let me just refer to the dates. It's 15 April 2019, and on 17 April 2019, the first defendant made payment of 71,000 Rand EFT with reference number that into the bank account. My lady, in terms of the dates, it makes no difference because the fact is it may well have been effective on the 15th. The fact is it's been repaid. That was the SASSA amounts, and it was repaid without even the need to come to court. When this amount was detected as having been paid, and Her Ladyship heard what was put to the witnesses, which they said they don't dispute, that when a patient is taken from the facility to another facility, SASSA don't update their details, and then they keep paying it through to the first defendant. But when they realized that there's overpayments, they paid this money over without the need for demands, without the need for anything. It's not money we're entitled to. You can have the money back, and that's not SASSA. Sorry, that's not the Department of Health. That's SASSA. So that's actually got nothing to do with the Department of Health. They go on and they say, but the point is, my lady, on their own version. So when it comes to the